Hello everybody. I'm Muriel Fox, and this is such a legendary gathering. Everyone in this room is a legend. And the wonderful thing is we're not a legend from the past. We are all still working for what we believe in. And that's true of everybody here. And that is thrilling to be sharing this together. I'm going to introduce very briefly Lynn Schafran, who is going to interview our legend of legends. I just wanted to say one thing about Lynn. Lynn is the director of the Judicial Education Project of Legal Momentum, formerly now Legal Defense and Education Fund. She also created this fantastic gender-biased task force, which has, in I don't know how many states it is now, over 30, right? Preventing gender bias in the courts and in the legal systems. And Lynn, I have to say, typifies of what the people in this room typify. Success through being so brilliant and competent and professional. And that is why everyone here has created the results we have created, because we have always been excellent and professional. And it is my privilege to introduce Lynn Schafran.
In 1980, when Justice Ginsburg was about to be sworn in as a judge of the D.C. Circuit Court of Appeals, she told me that there was a problem with respect to the room in the courthouse where this ceremony was going to be held. She told me that the beautiful ceremonial courtroom was too small, and that the room that was big enough to hold everybody was not very attractive. So I suggested that she could have her swearing in on the Washington Mall, and then all the women who were grateful to her could come. Now, about 2 weeks ago, one of the U.S. Marshals who provides security, I was not holding it so close because I thought you were getting bounce back, who provides security for Justice Ginsburg when she's in New York, called me up to ask about the nature of the event. And he was, kind of not coming right out and saying, is this going to be a friendly crowd? Are there going to be demonstrations? What's going to go on? I said, I think the word adulation would be the operative word for this event. This really is an occasion when the honoree needs no introduction to her audience, and I would say that her audience needs no introduction to her honoree, because so many of us in this room have had the wonderful good fortune of working with Justice Ginsburg through the years that she was a law professor, and later some of us have even appeared before her in her 2 judicial positions. She's been called the legal architect of the modern women's movement. She is, of course, the second woman on the U.S. Supreme Court. Your program materials have extensive biographical information about her and her cases. There is a tribute by Wendy Williams, Professor Wendy Williams of Georgetown, who is Justice Ginsburg's official biographer and is hard at work on that effort. There's information about her cases in a booklet that's in your materials called Key Cases for Women, edited by my colleague at Legal Momentum, Jennifer Brown. And we put that together for a book we created that I was the co-author of, which features very prominently a pop-up of Justice Ginsburg and Justice O'Connor in front of the Supreme Court. We are very honored that Justice Ginsburg would make time to be with us today. Our format is very informal. I get to ask leading questions for about half an hour, and then Justice Ginsburg has graciously agreed to take your questions. So my first question, Justice Ginsburg, is this. The years that we're focused on are 1963 to 1975. In 1963, you became one of the country's extremely few women law teachers when you were given a contract appointment as the second woman on the Rutgers Law School faculty. And you were hired because you were an expert on civil procedure. And that is what you began teaching insofar as I could find in my research. And then within a few years, you were doing litigation on behalf of women who were discriminated against in their employment circumstances. You created one of the first Women in the Law seminars. You began working on a textbook. And then you became the head of the newly established ACLU Women's Rights Project, which continues to this day. What caused you to switch from this intense focus that you had, even to the extent that you went to Sweden and learned Swedish to be able to write about their civil procedures? What took you onto the path that we are celebrating you for today?
It was that the women's movement came alive again in the 60s. Until then, I would say until 1963, it was hopeless to advocate for women's rights because you were in an era when people were not prepared to listen. And it wasn't until the 60s, it was not simply the civil rights movement that was going on, but there was a women's movement alive all over the world. Betty Friedan has been mentioned in this gathering, but before that, I mean, the woman who really opened my eyes was Simone de Beauvoir, her Second Sex. And that was published in '48 and republished many times. But my eyes were open. I guess 1963 was the year I was in Sweden. They were considerably ahead of us in that women, it was well accepted that a woman would be working, but also that she would have dinner on the table at 7, buy the children's new shoes and all the rest. There was a column in the Stockholm Daily paper to this effect: why should the woman have 2 jobs and the man only 1? It's not enough that he takes out the garbage. So there was that event, and then another one, also in Sweden. There was a woman named Sherry Finkbein. I don't know how many of you remember that name, but she had taken thalidomide and was at risk of having a terribly deformed fetus. She couldn't get an abortion in Arizona, so she came to Sweden, where she thought a safe abortion would be available to her, as it was. So it was that this woman from the United States could not exercise her choice in her own country, and this notion that it's right and proper for women to work, but it's right and proper for a man to be equal partner in bringing up the next generation and taking care of the home. So the idea was sparked then. There was still not very much that one could do about it, but by the late 60s there was, and I just was there in the right place at the right time. One of the things that we did, Lynn, and you're well aware of this, is Reed v. Reed was the turning point sex discrimination case in the Supreme Court. It was decided in 1971. It was the first time ever that the Supreme Court found a gender classification in the law unsatisfactory. I think most of you know what the law was. It was Sally Reed wanted to be appointed administrator of her teenage son's estate. He had committed suicide while in the custody of his father. And by the way, people think of the way the laws were, that mothers got preference for custody of children. Well, it wasn't necessarily so. It was the mother got preference when the child was of tender years, but Richard Lynn Reed was a teenager ready to be prepared for living in a man's world, so the judge thought the father should have custody anyway. Sally wanted to be the administrator of his estate. The law said, as between 2 persons equally entitled to administer a decedent's estate, males must be preferred to females. An ideal case, but if the Supreme Court was ever going to say that a law violates equal protection because it discriminates against women, it was that. Well, on the brief, we put two names as lead counsel. One was Pauli Murray, and the other was also Dorothy Kenyon. Those two women had been saying the same things that we were saying to the court, but they were saying it at a time when society was not yet ready to listen. So our point was that we had the great good fortune to be there at the right time when society would listen. But these great women said the same things that we were saying. And they kept the idea alive, although it wasn't possible for it to be successfully realized in the age that they were living.
When you mention Reed versus Reed, which was also noted this morning, I discovered that I was ignorant about a critical fact in that case in the course of preparing for today's interview. You're so strongly associated with that case that I just assumed that you argued it. But in point of fact, you didn't. You wrote the brief, but you didn't argue the case. That was very interesting to me. But you did argue 6 other cases before the Supreme Court, and you won 5, and you wrote an astonishing number of briefs or amicus briefs or certiorari petitions, basically in every important women's rights case that came along. And even if your name wasn't on it, you were consulting with the attorneys who were doing it. In terms of the challenges that you faced, they really come clear when you read Linda Greenhouse's biography of Justice Blackmun. I know that you and he ultimately became good friends, but he had some astonishing things to say about your arguments, and they're particularly astonishing to any of us who know you because he chose adjectives that are so inappropriate that we just have to wonder, what was going on there? He described the brief in Reed v. Reed as mildly offensive and arrogant. A very lengthy brief filled with emotion. Now, is there anyone who argues with more dispassion than Justice Ginsburg? I don't know. And then he graded some of your appearances before the court, and you never got an A from Justice Blackmun. I love the one where he called you too smart. But the one that I really liked was in 1976, you argued Califano versus Goldfarb, and Justice Blackmun wrote about your clothing. And this is a quotation, "In red and red ribbon today," close quote. Right? Now, I just thought that as I read this and the notes about your clothing and how unhappy these justices were that you were coming back and coming back and coming back, and I thought, he remembers her as being in red. Okay, so she's the matador twirling the cape, and she keeps sticking in those very pointy things and making us face up to things we don't want to face up to. And that's really, I just thought that these men were just in an emotional whirl over what you kept bringing to them. So my question is, what was the particular strategy that you had in mind when you wrote that emotional brief in Reed v. Reed? And I know this morning you talked a little bit about some of your strategy, but perhaps you'd like to talk more about your strategy over the course of these many cases. And then what was it like to argue in 1973? I tried to find out who was the second woman to argue in the Supreme Court after Belva Lockwood. And my Google skills are not that good, so perhaps you know, but there cannot have been many women in the middle. And so there you were in 1973, one of the first women to argue in the court, arguing a women's rights case. How did that feel? Just as Oprah would say, how did that feel, right? And then did it change over the years as you were arguing, the full panoply of cases that you had? Was that experience different?
The first case that I argued, and it was a divided argument, was Frontiero against Richardson. I divided it with Counsel for the Southern Christian Poverty. Yes. And I had, I think, 12 minutes of the argument. Joe Levin had the rest. I was up second. He was going to argue rational basis. This law fails even the rational basis test, and I was going to suggest heightened scrutiny, strict scrutiny. My argument went from beginning to end without an interruption. And I was dismayed. I said, are they so, do they think they're letting me just do this for a show? Why haven't they asked me any questions? And then was just amazed and delighted to see that in Justice Brennan's opinion, by the way, he was always happy to, I mean, he got it right from the beginning. Although it took a while for him to hire a woman as a law clerk. But anyway, he lifted whole passages of that brief and put it in the court's opinion in Frontiero against Richardson. And I think there's no higher compliment that a lawyer could have than that your brief shows up in the court's opinion. My husband is signaling to me that I'm not holding this correctly, so is it too low, too high? Okay, is that better? Good, okay. So, Lynn, I forgot what the question was.
I also asked, did anything change? I mean, you argued 6 cases over, several years. Did they ask you questions the second time out?
The last case that I argued before the court was Duran against Missouri. It was about the state of Missouri not putting women on juries if they didn't want to, if the women didn't want to serve. It worked this way. The clerk in Kansas City would send a notice that you were called for jury duty, and then it would say on the card, if you are a woman, you need not serve. If you don't want to serve, check off here. If the card was not returned, the clerk would make the assumption that the woman did not want to serve, with the result that the juries were virtually all male. And the public defender in Kansas City, in every case, complained that the jury was not selected from a pool that represented a fair cross-section. And in any case, that was a divided argument, too, with the Kansas City public defender. I was second, and when I got finished, I sat down with a great sense of relief because I got out all the essential points that I had planned to make. My later chief, then Associate Justice Rehnquist, said at the end of my argument, and so, Mrs. Ginsburg, you are not satisfied with Susan B. Anthony's face on the new dollar. This is 1978. It's still appropriate to make that kind of joke. Now, let me flash forward to my swearing-in ceremony at the court. Associate Justice Rehnquist is now the chief. My commission is going to be presented by Janet Reno. Most attorneys general like to be called general, but Janet Reno said she was not a military officer and she just wanted to be called Ms. Reno. The chief was not accustomed to using Ms., so we had a little dress rehearsal, and he said, Ms. Reno, a few times so that he would feel comfortable. Now, what a change from Susan B. Anthony's face on the new dollar to that wonderful moment when my commission was presented by our then Attorney General, Ms. Janet Reno.
This morning, there was mention of your decision in the Virginia Military Institute case. And what I've always been struck by in reading that opinion is how extraordinary that the person who wrote the opinion got to write so many, that so many of the precedents cited in that case were her cases. And that really is a very striking thing about VMI. But excuse me, it seems as we look back on that opinion, which came down in 1996, that those were halcyon days in terms of most of the justices' attitudes toward women's rights. And the difference certainly was very stark this year when we had the Lilly Ledbetter case. And since you are noted for being deeply committed to collegiality, this was something that your colleagues and commentators always spoke about when you were on the D.C. Circuit Court of Appeals and certainly on the Supreme Court. The fact that you chose to read your dissents aloud in the Ledbetter case and then in the Carhart abortion rights case was very striking to many people. In fact, I noted today that the organizers of our event even put into the materials that you've all received in that booklet a column that Ellen Goodman wrote about the fact that you elected to make those very strong statements from the bench. So what made you feel that you needed to not just publish your dissent as is typical, but actually make those statements orally from the bench at the same time that the majority opinion was announced?
One reads a dissent when one thinks that the court's opinion is not just wrong, but grievously so. And that was you know, I've been on the court now for 15 years, it's hard to believe. And I had a total of, I think up till then, something like 6 dissents announced from the bench. And that year, I announced 2. Never before had I announced 2, and most years, none. My dissent was written and people could read it, but I wanted to capture the attention of the public, and in Lilly Ledbetter's case, the attention of Congress. You know, there was a corrective bill that passed the House easily. It stalled in the Senate, and perhaps one of the reasons is that the White House announced that if the bill passed, the president's advisors would counsel him to veto the measure. But the measure is there, and I am confident that in another Congress it will be passed. I can also say, you know, the court was criticized rather strongly for its blindness in that case. So far this year, the discrimination cases, the employment discrimination cases, have all gone for the challenger. So maybe there has been some rethinking of what the court did in the Ledbetter case.
Young women lawyers are deeply concerned about the question of whether they can have a successful and demanding career and also have children whom they see in daylight. And there are also increasing numbers of young men lawyers who are asking that question. Now, you and your husband, Marty Ginsburg, who is here today, who is a tax lawyer and a professor, you raised 2 very successful children. Many of you know that Jane is a law professor at Columbia and an international authority on intellectual property. I learned today that James, who produces classical music records, won 2 Grammys this year. So 2 very successful progeny, and you did it while the 2 of you had both extremely demanding careers. So for young women who are wondering how you did it, and how they might do it, what are your words of sage advice?
have a life's partner who thinks your work is at least as important as his, and who is a great chef. So Marty sustains me in every way, really. I was phased out of the kitchen by my food-loving children before we even moved to D.C. And even now, the kitchen is totally Marty's domain. I'm not allowed to do anything in it. But the truth was that, well, we married what by today's standards would be rather young. Marty was 22 and I was 21. And we had a notion that whatever we did, we were going to do together when we were students at Cornell. Well, medical school was a possibility, but that lost out to golf practice because there were labs in the afternoon. And then we thought about business school. Marty, for some reason, wanted to go to Harvard, and the Harvard Business School did not admit women until sometime in the 60s. So there we were, left with law school. And I think you need to have the people around you, closest to you, have to be in your corner. If they're not, it's terribly difficult.
One last question, and then we're going to go to Q&A. This is prompted by the fact that Judicature magazine, which is put out by the American Judicature Society, has a very long article in the spring issue that's called The Attorney Gender Gap in U.S. Supreme Court Litigation. It's by 3 political scientists, and they analyze the number of women and men attorneys arguing to the Supreme Court in the years 1993 to 2001. And the numbers come out to 150 out of 1,078. 14% were women lawyers. And the thing that's also particularly interesting about the finding is that there was, even in the women's rights cases, the people arguing, going back to Reed v. Reed, are men or men on one side. They couldn't identify any case where there were women on both sides in a women's rights case. So that analysis ended in 2001, and I wondered if you've seen any improvement in those figures in the years since, and if you have any advice for women who would like to develop a Supreme Court practice, maybe some of the women in this room.
I wouldn't recommend that anyone aim for a Supreme Court practice unless you have another source of income. I mean, we take so few cases. We have had, Lynn, we've had more than an occasional case in which women were on both sides. The Supreme Court tends to trail other institutions with respect to change. So I wish I could tell you that there has been a steep rise in the number of women arguing before the court. I can tell you one positive thing. It came to my attention, I don't know who suggested it to me, that in all the years the Supreme Court has been in existence, there has never been a woman appointed special master in a case. So that was the last threshold that women had not crossed. Well, just a few months ago, Chief Justice Roberts announced that a woman had been appointed as special master in a case, I think it's between North Carolina and South Carolina, some watery rights case. But so that now there's nothing that a woman hasn't done. There are not enough women. It's true not only about the women who argue before the court, but also the law clerks. The court has done better this year than last year when they were really at the bottom with only 7 women clerking. But what we see more and more are law clerks with children, and no one thinks that's a large problem. I have one clerk this year with, I think her boys are 8 and 10, Justice Scalia has had women with raising children. Now, years ago, that would have been an unthinkable combination. How could we hire a mother as a Supreme Court clerk? Well, now there have been a number of mothers, and they've done a very good job. So that's not an issue. So the returns are mixed. I expect that as more women become specialists in appellate advocacy, we will see more women arguing before the court. But there are certainly more women arguing before the court now than there were when I was a young lawyer.
So Justice Ginsburg has very kindly agreed to take questions, and Sheila Tobias is going to walk around with the mic so that you can be heard.
Barbara Babcock from California, and I just wanted to say a couple of things. One is that between Belva and Ruth, there was B. Rosenberg, who argued a lot of cases in the Supreme Court, and there was a famous woman patent attorney from Chicago, whose name I can't remember, but if you want to learn more about this, Google Women's Legal History, and the first thing that comes up is a website that we run from Stanford that has a lot of this history on it. And then I just wanted to say one other little thing about history. One other thing about the doors that are still closed. The best legal job in the country, Solicitor General, never a woman. And then the third thing, I just wanted to reminisce for a minute. When I first came into academia, people thought that Ruth Ginsburg was ruining a very promising career by taking these stupid women's cases. And so that it was the sweetest thing. Her appointment was the sweetest thing to me for that reason. So I just wanted to share that.
May I say that I would not be standing here today were it not for Barbara Babcock, because if you remember Carter, when he became president, there was one woman on a court of appeals in the entire country. She was only the second in history, Shirley Hofstetler. Carter made her the first ever Secretary of Education, and then there were none. But he was determined to change the complexion of the U.S. judiciary by appointing members of minority groups and women in numbers. Well, my name was one of the names on the list for appointment to the D.C. Circuit. But not much was happening. Barbara was in my corner, and the first thing that she did, Barbara, I think you can confirm that this was right, is you got Judge Bazelon to take senior status. Judge Bazelon had been the chief of the D.C. Circuit forever, and he wasn't inclined to take senior status. I think you told him that he risked having someone that he wouldn't like so much appointed. So that cleared the way for Harry Edwards. And then I got the next seat on the D.C. Circuit. So Barbara, by the way, was then was head of the Civil Division in the Department of Justice, the largest division by far at Justice.
Good. Nancy, we're going to give our honorees a little bit of preference, and if there's time,
I'm Nancy Stanley. I'm from Washington, D.C., and I have two little bits of history to add. The first is that when Barbara Babcock was the Assistant Attorney General for the Civil Division, she was appointed to a committee to vet judicial appointments around the country and to encourage the appointment of women. And because she was very busy with other things, she needed an emissary to attend these meetings in her stead. And I was that emissary. And it was a wonderful experience to participate in these meetings, which were kind of informal. I remember there was a big chart on the wall with all the open vacancies listed and with prospective candidates slotted into that chart, and you'd go into this room once a week and sit around a big table and discuss who might be appropriately moved up or down. So I regard that as one of the highlights of my insider career at the Department of Justice, and we did do some good things and got the appointments of some wonderful women. The other thing is I just wanted to mention that the context in which B. Rosenberg argued so many cases before the Supreme Court is that after the war, and I'm not sure I have the dates right, maybe the 50s and 60s, B was the criminal appellate chief at the Department of Justice, and so she was the person who was arguing many of the criminal cases that came before the Supreme Court. On the wrong side. But as a footnote, there's a biography, or maybe it's an autobiography of Justice Douglas, I can't remember the name, in which he names B. Rosenberg as one of the 2 or 3 best advocates he had ever seen before the U.S. Supreme Court.
Come to the United States from, I think, Czechoslovakia. She wanted to become a citizen. She said she was prepared to take an oath to support and defend the Constitution of the United States. And she was then asked, "Are you willing to bear arms?" And she said, "Well, I've been a pacifist all my life, and no, I will not bear arms." So she was turned down for citizenship. There was a young woman, a lawyer in Chicago, that was this Olive Rabb, who took her case. She was a volunteer lawyer for the ACLU, and I had never appreciated what that woman did. She won in the Seventh Circuit, but then the case went the wrong way in the Supreme Court. I was thinking of the case recently because the Second Amendment has been on my mind, but one of the things that she said was, "Well, why are you asking me that question? I couldn't bear arms if I wanted to. You don't take women in the military." That's how irrational things were. And the Supreme Court, anyway, refused to hold that there was anything unconstitutional about denying her citizenship because she was a pacifist. But there was this Olive, and
any questions, if possible, not it's our opportunity to hear her.
Justice Ginsburg, I come from the state of Washington, where several times in the last decade we've had a majority of our Supreme Court as female. And I'm wondering if you see any future in the Supreme Court of the United States having a majority of justices female.
Well, I certainly do, and people ask me, I just came here from my Second Circuit Judicial Conference, and one of the questions I was asked was, what do I think of the idea of having seats reserved to be sure that the next appointee is a woman? I said that I see in the fullness of time that there will be many, many women. There'll be so many women that maybe we would think seriously about having one seat reserved for a white male. You know, we are terribly behind in that respect if you look at the U.S. Supreme Court, but look at our state courts. 17 state Supreme Courts are now headed by women. There have been 10 women who were chief judges of a federal circuit. That's an enormous change from the way it was in the not-so-good old days. The states of North Carolina, South Carolina, and Georgia each has a woman as the chief judge. And these are women who are super bright and very well respected.
Thank you. My name is Barbara Berg, and I would like to ask you what you think the prospects and future of Roe v. Wade are in our country, particularly if you would please comment on the movement in America to declare fetuses personhood and to give them those rights.
Well, Sarah Weddington is here, and, you know, she argued Roe v. Wade. And I should say that she's another person responsible for my appointment to the D.C. Circuit because she was counsel to President Carter at the time, and it really urged my nomination incessantly. People tend to think that, well, Roe v. Wade has to be preserved at all costs. What has to be preserved is the right of a woman to have access to the means to control her own reproductive capacity. And it has to be much more than the bare right of a woman of means to obtain an abortion, because that's all that I mean, that our government has a policy that there is no Medicaid reimbursement for abortion, that there is for childbirth. I think that the concentration really should be at the legislative level, in the states, and in Congress, assuming the composition of Congress will continue to change as it has recently. But I would never put my faith in one single Supreme Court decision. The work really has to start at the local level. I remember once in New York just trying to find out how hard it was for a poor woman even to get an IUD, and it was terribly hard. That's the group that we should be concerned about.
I'm going to make an arbitrary decision, make this the last question, because we have 30 honorees from New York here.
Hi, my name is Merle Hoffman, and I want to follow up on your question about abortion rights. Thank you. I read a paper of yours written many years ago where you were stating that you really didn't believe that the fundamental right of reproductive freedom should be based on the right to privacy, but I think it's on the 13th Amendment or the 14th against slavery, because obviously if a woman is forced to bear a child against her will, I would consider that a form of slavery. Do you think there's any way that lawyers now should be working towards recasting the argument of reproductive freedom, taking it away from Roe and the right of privacy to something much deeper?
Well, I think lawyers have argued that in the Casey case, for example, that it's not privacy in the sense that this is something I want to do and hide from everybody and seal myself in a cocoon. It's autonomy is the idea. It's a woman's right to choose. And I have criticized the court's decision in Roe v. Wade, not, of course, for the result, but that decision is heavily oriented to doctors. It's the doctor's choice as much as the woman's. The government shouldn't regulate what doctors decide is best for the patient. But I think the notion of a woman's autonomy to determine her life's course, that has come more and more into the more recent cases. Of course, the most recent case is a flip-flop from, the court had held that Nebraska's so-called partial birth abortion law had held that that was unconstitutional because it didn't have a reservation for a woman's health. Then Congress passed a law to the same effect, and the court 5-4 upheld that federal law. What was the difference? One person, Justice O'Connor, was no longer on the court. But I think the notion that it isn't just some private act, it is a woman's right to control her own life.
I want to thank you, Ruth and Lynn. And Laurie,
ready for cooking breakfast. I'm kidding.